Two general classes of life policies. 1. Insurance upon one's life, are those taken out by the insured upon his own life for the benefit a. of himself, b. of his estate, in case it matures only at his death, c. of third person who may be designated as beneficiary. The question of insurable interest is immaterial where the policy is procured by the person whose life is insured. A person who insures his own life can designate any person as his beneficiary. Whether or not the beneficiary has an insurable interest in the life of the insured subject to the limits under Article 2012 in relation to Article 739 of the new Civil Code. Q. X is the common law wife of Y. Y loves X so much that he took out a life insurance on his own life and made her the sole beneficiary. Y did this to ensure that X will be financially comfortable when he is gone. Upon the death of Y, who should be entitled to the proceeds? A. X as sole beneficiary under the life insurance policy on the life of Y will be entitled to the proceeds of the life insurance. Q. On July 3, 1993, Delia Sotero took out a life insurance policy from Ilico's Bankers Life Insurance Corporation designating Creencia Abon her niece as her beneficiary. Ilico's Life issued policy number 747, with a face value of P100,000, in Sotero's favor on August 30, 1993, after the requisite medical examination and payment of the premium. On April 10, 1996, Sotero died. Abon filed a claim for the insurance proceeds on July 9, 1996. Ilico's Life conducted an investigation into the claim and came out with the following findings. 1. Sotero did not personally apply for insurance coverage, as she was illiterate. 2. Sotero was sickly since 1990. 3. Sotero did not have the financial capability to pay the premium on the policy. 4. Sotero did not sign the application for insurance. 5. Albin was the one who filed the insurance application and designated herself as the beneficiary. For the above reasons and claiming fraud, Ilico's Life denied Abon's claim on April 16, 1997 but refunded the premium paid on the policy. May Sotero validly designate her niece as beneficiary? A. Yes. Sotero may validly designate her niece as beneficiary. The same is not prohibited under the Insurance Code or any other laws pertinent to the problem. 2. Insurance upon life of another, are those taken out by the insured upon the life of another. Where a person names himself beneficiary in a policy he takes on the life of another, he must have insurable interest in the life of the latter. This class includes the following. A. His spouse and of his children. B. Any person on whom he depends wholly or in part for education or support, or in whom he has a pecuniary interest. C. Of any person under a legal obligation to him for the payment of money, or respecting property or services, of which death or illness might delay or prevent the performance. D. Of any person upon whose life any estate or interest vested in him depends, i.c. seconds. 10. Note: in paragraph of Section 10 of the Insurance Code, mere relationship is sufficient while the rest, pars. B, C, and D, requires pecuniary interest. Thus, the interest of the creditor over the life of the debtor ceases upon full payment. Persons prohibited from being designated as beneficiaries. Under the Article 739 in relation to Art. 2012 of the new Civil Code, the following are prohibited designation of beneficiaries. 1. Those made between persons who were guilty of adultery or concubinage at the time of donation. Note: the guilt of the donor and done may be proved by preponderance of evidence in the same civil action. Criminal conviction is not necessary. 2. Those made between persons found guilty of the same criminal offense, in consideration thereof. 3. Those made to a public officer or his wife, descendants, or ascendants by reason of his office. The designation of the above enumerated persons is void, but the policy is binding. The estate will get the proceeds. Art. 2012. Any person who is forbidden from receiving any donation under Art. 739 cannot be named beneficiary of a life insurance policy by the person who cannot make any donation to him, according to said article. Note: a beneficiary in a life insurance policy is no different from a donee. Both are recipients of pure beneficence. So long as marriage remains the threshold of family laws, reason and morality dictate that the impediments imposed upon married couple should likewise be imposed upon extramarital relationship. If legitimate relationship is circumscribed by these legal disabilities, with more reason should an illicit relationship be restricted by these disabilities. Insular Life v. Ibradu Gr. No. 44059 October 28, 1977. Beneficiary willfully brought about the death of the insured. Gr. The interest of a beneficiary in a life insurance policy shall be forfeited when the beneficiary is the principal, accomplice, or accessory in willfully bringing about the death of the insured. In such a case, the share forfeited shall pass on to the other beneficiaries, unless otherwise disqualified. In the absence of other beneficiaries, the proceeds shall be paid in accordance with the policy contract. If the policy contract is silent, the proceeds shall be paid to the estate of the insured. XBNs. 1. Insanity of the beneficiary at the time he killed the insured. 2. The insured's death was unintentionally caused. 3. The beneficiary acted in self-defense. Q. Juan de la Cruz was issued policy number 8888 of the Midland Life Insurance Co. on a whole life plan for P20,000 on August 19, 1989. Juan is married to Cynthia, with whom he has 3 legitimate children. He, however, designated Purita, his common-law wife, as the revocable beneficiary. Juan referred to Purita in his application and policy as the legal wife. 3 years later, Juan died. Purita filed her claim for the proceeds of the policy as the designated beneficiary therein. The widow, Cynthia, also filed a claim as the legal wife. To whom should the proceeds of the insurance policy be awarded? A. The estate is entitled to claim for the proceeds of the insurance policy. As a general rule, the insured may designate anyone he wishes to be his/her beneficiary. However, Art. 2012 of the Civil Code, which applies suppletorily to the Insurance Code, provides that any person who is forbidden from receiving any donation under Art. 739 cannot be named beneficiary of a life insurance policy by the person who cannot make any donation to him, according to said article. Art. 739 specifically bars the donations as between persons who were guilty of adultery or concubinage. Since Purita is a common-law wife of Juan, she falls squarely into this category, therefore she is disqualified to receive insurance proceeds, and when this happens, the estate of the deceased is the one entitled to the proceeds. Insular Life Assurance Company, Ltd vs. Caprinia Ibradu, Supra. Q. Loreto designated Eva, his common-law wife, and illegitimate children as beneficiaries in his life insurance policies. Loreto was killed and Eva was the prime suspect in his death. The legitimate wife and children of Loreto asked for the insurance proceeds, contending that illegitimate family is disqualified from being beneficiaries and that the insurance benefits must redound to the benefit of the estate of Loreto. Will the claim of the legitimate family prosper? A. No. The insurance proceeds shall be applied exclusively to the proper interest of the person in whose name or for whose benefit it is made, unless otherwise specified in the policy. While the share of Eva must be forfeited, the designation of the illegitimate children as beneficiaries remains valid. There is no proscription in naming illegitimate children as beneficiaries. It is only in cases where the insured has not designated beneficiary or when the designated beneficiary is disqualified by law to receive the proceeds, that the policy proceeds shall redound to the benefit of the estate of the insured. Thus, the proceeds of the policy must be awarded to the illegitimate children, to the exclusion of the legitimate family. In property, every interest in property, whether real or personal, or any relation thereto, or liability in respect thereof, of such nature that contemplated peril might directly damnify the insured, is insurable interest. Insurable interest in property may consist of the following. 1. An existing interest. The existing interest in the property may be legal or equitable title. Examples of insurable interest arising from legal title: A trustee, as in the case of the seller of property not yet delivered, B mortgager of the property mortgaged, or C lessor of the property leased. Examples of insurable interest arising from equitable title: A. Purchaser of property before delivery or before he has performed the conditions of the sale, B mortgagee of property mortgaged, or C mortgager, after foreclosure but before the expiration of the redemption period. 2. An inchoate interest founded on an existing interest. Example: A stockholder has an inchoate interest in the property of the corporation of which he is a stockholder, which is founded on an existing interest arising from his ownership of shares in the corporation. 3. An expectancy coupled with an existing interest in that out of which the expectancy arises. Note: existence of insurable interest is a matter of public policy. Hence, the principle of estoppel cannot be invoked. Measure of insurable interest in property. Under Sector 17, the measure of insurable interest in property is the extent to which the insured might be damnified by loss or injury thereof. Insurable interest in property does not necessarily imply a property interest in, or lien upon, or possession of, the subject matter of the insurance, and neither title nor a beneficial interest is requisite to the existence thereof. It is sufficient that the insured is so situated with reference to the property that he would be liable to loss should it be injured or destroyed by the peril against which it is insured. Anyone has an insurable interest in property who derives a benefit from its existence or would suffer loss from its destruction. A common carrier or depository's extent of insurable interest in a thing held by him. A carrier or depositary has an insurable interest in a thing held by him as such, to the extent of his liability but not to exceed the value thereof. Because the loss of the thing by the carrier or depository may cause liability against him to the extent of its value. Change of interest in any part of a thing insured. Change of interest contemplated by law is an absolute transfer of the insured's entire interest in the property insured to one not previously interested or insured. Gr. A change of interest in any part of a thing insured unaccompanied by a corresponding change in interest in the insurance suspends the insurance to an equivalent extent, until the interest in the thing and the interest in the insurance are vested in the same person. Expiens. 1. When there is a prohibition against alienation or change of interest without the consent of the insurer, in which case the policy is not merely suspended but avoided. Sundiang and Aquino, 2014, citing Curtis vs. Gerard Fire and Marine INS, 11 SE 3, 190 GA 954. 2. In life, accident, and health insurance. IC, seconds. 20. 3. A change of interest in a thing insured, after the occurrence of an injury which results in a loss, does not affect the right of the insured to indemnity for loss. Note: after the occurrence of the peril insured against, the insured acquired a vested right over the proceeds of the policy. 4. A change of interest in one or more distinct things, separately insured by one policy, does not avoid the insurance as to the others. 5. A change of interest by will or succession, on the death of the insured, does not avoid an insurance, and his interest in the insurance passes to the person taking his interest in the thing insured. 6. A transfer of interest by one of several partners, joint owners, or owners in common, who are jointly insured, to the others does not avoid an insurance even though it has been agreed that the insurance shall cease upon an alienation of the thing insured, IC. Seconds. 24. 7. When the policy is so framed that it will inure to the benefit of whomsoever, during the continuance of the risk, may become the owner of the interest insured. Double insurance and over-insurance. Double insurance exists where the same person is insured by several insurers separately, in respect to the same subject and interest. Requisites of double insurance. One subject matter is the same to 2 or more insurers insuring separately. 3. Risk or peril insured against is the same. 4. Interest insured is the same. 5. Person insured is the same. There is no double insurance even though 2 policies were both issued over the same subject matter and both covered the same peril insured against if the 2 policies were issued to 2 different entities. Malayan Insurance COVS. Philippine First Insurance CO, GR number 184300, July 11, 2012. Double insurance is not prohibited by law. It is not contrary to law and hence, in case of double insurance, the insurers may still be made liable up to the extent of the value of the thing insured but not to exceed the amount of the policies issued. A provision in the policy that prohibits double insurance is valid. However, in the absence of such prohibition, double insurance is allowed. Nature of the liability of the several insurers in double insurance. In double insurance, the insurers are considered as co-insurers. Each one is bound to contribute ratably to the loss in proportion to the amount for which he is liable under his contract. This is known as the principle of contribution or contribution clause. Overinsurance. There is overinsurance whenever the insured obtains a policy in an amount exceeding the value of his insurable interest. Rules when the insured in a policy other than life is overinsured by double insurance. 1. The insured, unless the policy otherwise provides, may claim payment from the insurers in such order as he may select, up to the amount which the insurers are severally liable under their respective contracts. 2. Where the policy under which the insured claims is a valued policy, any sum received by him under any other policy shall be deducted from the value of the policy without regard to the actual value of the subject matter insured. 3. Where the policy under which the insured claims is an unvalued policy, any sum received by him under any policy shall be deducted against the full insurable value, for any sum received by him under any policy. 4. Where the insured receives any sum in excess of the valuation in the case of valued policies, or of the insurable value in the case of unvalued policies, he must hold such sum in trust for the insurers, according to their right of contribution among themselves. 5. Each insurer and the other insurers, to contribute ratably to the loss in proportion to the amount for which he is liable under his contract. Additional or other insurance clause. A clause in the policy that provides that the policy shall be void if the insured procures additional insurance without the consent of the insurer. Pioneer Insurance and Surety Corp vs Yap, GR No. L36232, December 19, 1974. The insurer may insert an other insurance clause to prevent the danger that the insured will overinsure his property and thus avert the possibility of perpetration of fraud. It is lawful and specifically allowed under Sections 75 of the Insurance Code, which provides that a policy may declare that a violation or a specified provision thereof shall avoid it, otherwise the breach of an immaterial provision does not avoid it. Waiver of violation when the insurer, with the knowledge of the existence of other insurances, which the insurer deemed a violation of the contract, preferred to continue the policy. Its action amounted to a waiver of annulment of the contract. Q. Wyeth Philippines, Inc. procured a marine policy from Philippines First Insurance Co., Inc. to secure its interest over its own products while the same were being transported or shipped in the Philippines. Thereafter, Wyeth executed its annual contract of carriage with Reputable Forwarder Services, Inc. Under the contract, Reputable undertook to answer for all risks with respect to the goods and shall be liable to Wyeth for the loss, destruction, or damage of the goods/products due to any and all causes whatsoever, including theft, robbery, flood, storm, earthquakes, lightning, and other force majeure while the goods/products are in transit and until actual delivery to the customers, salesmen, and dealers. The contract also required Reputable to secure an insurance policy on Wyeth's goods. Thus, Reputable signed a special risk insurance policy with Malayan Insurance Co. Inc. for the amount of P1,000,000.00. There is double insurance so as to preclude PFIC from claiming indemnity from Malayan? A. No. The interest of Wyeth over the property subject matter of both insurance contracts is different and distinct from that of Reputable's. The policy issued by PFIC was in consideration of the legal and/or equitable interest of Wyeth over its own goods. On the other hand, what was issued by Malayan to Reputable was over the latter's insurable interest over the safety of the goods, which may become the basis of the latter's liability in case of loss or damage to the property and falls within the contemplation of Section 15 of the IC. Therefore, even though the two concerned insurance policies were issued over the same goods and cover the same risk, there arises no double insurance since they were issued to two different persons/entities having distinct insurable interests. Necessarily, over-insurance by double insurance cannot likewise exist. Malayan Insurance Co., Inc., v. Philippine First Insurance Co., Inc., and Reputable Forwarder Services, Inc., GR number 184300, July 11, 2012. Absence of notice of existence of other insurance constitutes fraud. When the insurance policy specifically requires that notice should be given by the insured of the existence of other insurance policies upon the same property, the total absence of such notice nullifies the policy. Such failure to give notice of the existence of other insurance on the same property when required to do so constitutes deception, and it could be inferred that had the insurer known that there were many other insurance policies on the same property, it could have hesitated or plainly desisted from entering into such contract. No policy of insurance shall be cancelled except upon notice thereof to the insured. Q. The Peninsula Insurance Company offered to insure Francis brand new car against all risks in the sum of P1 million for 1 year. The policy was issued with the premium fixed at P60,000.00 payable in 6 months. Francis only paid the first 2 months' installments. Despite demands, he failed to pay the subsequent installments. 5 months after the issuance of the policy, the vehicle was carnapped. Francis filed with the insurance company a claim for its value. However, the company denied his claim on the ground that he failed to pay the premium, resulting in the cancellation of the policy. Can Francis recover from the Peninsula Insurance Company? A. Yes. As a general rule, no policy is binding unless the premiums thereof have been paid. However, one of the exceptions is when there is an agreement allowing the insured to pay the premium in installments and partial payment has been made at the time of loss. In the case at hand, Francis already paid 2 installments at the time of the loss and as such may recover on the policy. Furthermore, The contention of the insurer that the failure to pay premium resulted in the cancellation of the policy is not tenable, since no policy of insurance shall be cancelled except upon notice thereof to the insured, IC, seconds. 64. Cancellation of policy of insurance by reason of overinsurance. Sector 64 of the IC provides that upon discovery of other insurance coverage that makes the total insurance in excess of the value of the property insured, the insurer may cancel such policy of insurance. Circumstance occurred after the effective date of the policy. Multiple or several interests on same property. Instances where more than one insurable interest may exist in the same property. 1 trust, both trust or entrustee have insurable interest over the property in trust. 2 corporation, both the corporation and its stockholders have insurable interest over the assets. 3 partnership, both the firm and partners have insurable interest over its assets. 4 assignment, both the assignor and assignee have insurable interest over the property assigned. 5 lease, the lessor, lessee, and sublessees have insurable interest over the property in lease. 6 mortgage, both the mortgager and mortgagee have insurable interest over the property mortgaged. Insurable interest of mortgager and mortgagee in case of a mortgaged property are not the same. Each has an insurable interest in the property mortgaged, and this interest is separate and distinct from the other. Therefore, insurance taken by one in his name only and in his favor alone does not inure to the benefit of the other. The same is not open to objection that there is double insurance, RCBCVS. CA 289 GRNOS 128,833-34, 128,866, April 20, 1998, IC, Sector 8. Extent of insurable interest of mortgager and mortgagee. 1 mortgager, the mortgager of property, as owner, has an insurable interest to the extent of its value even though the mortgage debt equals such value. 2 mortgagee, the mortgagee as such has an insurable interest in the mortgaged property to the extent of the debt secured, such interest continues until the mortgage debt is extinguished. Note: in case of an insurance taken by the mortgagee alone and for his benefit, the mortgagee, after recovery from the insurer, is not allowed to retain his claim against the mortgager, but it passes by subrogation to the insurer to the extent of the insurance money paid. Q. To secure a loan of P10 million, Mario mortgaged his building to Armando. In accordance with the loan arrangements, Mario had the building insured with First Insurance Com for P10 million, designating Armando as the beneficiary. Armando also took an insurance on the building upon his own interest with Second Insurance Company for P5 million. The building was totally destroyed by fire, a peril insured against under both insurance policies. It was subsequently determined that the fire had been intentionally started by Mario and that in violation of the loan agreement, he had been storing inflammable materials in the building. A. How much, if any, can Armando recover from either or both insurance companies? B. What happens to the P10 million debt of Mario to Armando? Explain. A. Armando can receive P5 million from Second Insurance Company. As mortgagee, he had an insurable interest in the building. Armando cannot collect anything from First Insurance Co. Since the latter is not liable for the loss of the building. First, it was due to a willful act of Mario, who committed arson. Second, fire insurance policies contain a warranty that the insured will not store hazardous materials within the insured premises. Mario breached this warranty when he stored inflammable materials in the building. These two factors exonerate First Insurance Co. from liability to Armando as mortgagee even though it was Mario who committed them. B. Since Armando would have collected P5 million from Second Insurance Company, this amount should be considered as partial payment of the loan. Armando can only collect the balance of P5 million. Second, insurance CO can recover from Mario the amount of P5 million it paid, because it became subrogated to the rights of Armando. Standard or union mortgage clause. It is a clause that states that the acts of the mortgager do not affect the mortgagee. The purpose of the clause is to make a separate and distinct contract of insurance on the interest of the mortgagee. Open or loss payable mortgage clause. It is a clause which provides for the payment of loss, if any, to the mortgagee as his interest may appear, and under it, the acts of the mortgager affect the mortgagee. In a policy obtained by the mortgager with loss payable clause in favor of the mortgagee as his interest may appear, the mortgagee is only a beneficiary under the contract, and recognized as such by the insurer but not made a party to the contract itself. This kind of policy covers only such interest as the mortgagee has at the issuance of the policy. The mortgagee may be made a beneficial payee through any of the following. 1. He may become the assignee of the policy with the consent of the insurer. 2. He may be the pledgee without such consent of the insurer. 3. A rider making the policy payable to the mortgagee as his interest may appear may be attached, or 4. A standard mortgage clause containing a collateral independent contract between the mortgagee and the insurer may be attached. The policy, though, by its terms payable absolutely to the mortgager, may have been procured by a mortgager under a contract duty to insure for the mortgagee's benefit, in which case the mortgagee acquires an equitable lien upon the proceeds. Effects. If the insurance is procured by mortgager for benefit of mortgagee, or policy assigned to mortgagee. 1. The contract is deemed to be upon the interest of the mortgager, hence he does not cease to be party to the contract. 2. Any act of the mortgager prior to the loss, which would otherwise avoid the insurance, affects the mortgagee even if the property is in the hands of the mortgagee. 3. Any act which under the contract of insurance is to be performed by the mortgager may be performed by the mortgagee with the same effect. 4. In case of loss, the mortgagee is entitled to the proceeds to the extent of his credit at the time of loss end. 5. The debt is extinguished upon recovery by the mortgagee to the extent of his credit. Note: the rule on subrogation by the insurer to the right of the mortgagee does not apply in this case. Assignment of policy to mortgagee is not a payment. The assignment is merely to afford the mortgagee a greater security for the settlement of the mortgager's obligation and should not be construed as payment in just the same way that delivery of negotiable instruments does not constitute payment until the proceeds are realized or collected. Note: the exception of this rule is the mortgage redemption insurance. Effects of mortgage redemption insurance procured by the mortgager. A mortgage redemption insurance is simply a kind of life insurance procured by the mortgager, with the mortgagee as beneficiary, up to the extent of the mortgage indebtedness. Its rationale is to give protection to both the mortgagee and the mortgager. In case the mortgager insured dies, the proceeds of such insurance will be applied to the payment of the mortgage debt to the mortgagee, thereby relieving the heirs of the mortgager of the burden of paying the debt. Great Pacific Assur Corp. VCA, ET. Al. GR number 113899, October 13, 1999.